I'm going to go dark, and it's other panel. Thank you very much.
Yeah. So
you are live.
Thank you very much, Vinicius. And my name is Giacomo Pailli. I'm a member of the International Advisory Board of the Institute of Competition. And I welcome today two very distinguished panelists. First, Dr. Till Schreiber, who is Managing Director of Cartel Damage Claims. Cartel Damage Claims is a real pioneer in the context of private enforcement in Europe. And he will tell much more about what CDC has done for private enforcement in the context of the European Union. And he also has a background as a practicing lawyer before joining in 2007 CDC, and holds a PhD in competition law in the context of Mercosur. And also I welcome and thank Professor Giorgio Afferni. He's a professor of private law in the University of Genoa, also a practicing lawyer and a real expert in private enforcement, passing on, and all these very interesting topics. So today we ask our panelists to address the two of the main models of private enforcement, or of pulling together many damaged victims from anti-competitive behaviors. So assignment of claims and collective redress mechanism, class action, to be specific. And we would like to know what are the pros and cons of both methods. And Dr. Schreiber will tell us something about assignment and transfer of claim. That is one of the main tools that CDC uses for private enforcement, while Professor Afferni will focus more on the collective redress class action side. So I don't want to steal any more time, and I give the floor to Dr. Schreiber, and thank you very much once again for joining us.
Yeah, thank you, Giacomo, and thank you everybody for inviting me. It's really an honor to speak to you. And as Giacomo said, I have some links to South America. I wrote my PhD thesis some 15 years ago about competition law in the Mercosur. At that time, private enforcement did not exist yet, neither in the context of the European Union nor in Mercosur, but things are changing over time. And I will, the title of today's webinar is Class Actions versus Transfer of Claims, Pro and Cons. I would not necessarily say it's a versus. I think ideally both solutions are alternatives, and I will speak to you about the model of the transfer of claims, which is based on the practical experience of CDC cartel damage claims. So who and what is cartel damage claim? So we are a company that is purely focusing on private enforcement in the field of antitrust damage claims. So the situation at the time when CDC started its activities in 2003 was that there was no collective action mechanism in place. CDC started its activities in Belgium and in Germany, but there were cartels such as, for example, the German cement cartel case, where multiple small and medium-sized companies were harmed by one and the same antitrust infringement, i.e. either a national or even a pan-European cartel. The infringers, i.e. the cartel members, were typically larger and structurally more powerful than those victims of the anti-competitive conduct. And often the victims even depended on the cartelists for supply purposes, etc. As you know, in cartels, there's also an inherent information asymmetry, because cartels are secret by nature, and therefore, as a victim, you do not necessarily know what happened in the market due to the anti-competitive infringement. Therefore, you typically depend on competition authorities establishing infringements and describing in detail the infringements that took place, i.e., you typically want to base your claim on a so-called follow-on situation where you have an administrative fining decision that establishes the infringement. One of the main challenges in the antitrust damage world is, of course, the inherent difficulties as well for individual companies to quantify the exact damage. And depending on the size of the company, damage claims may often be too small to merit a long-lasting and complex litigation, in particular if the costs for lawyers and economists are high and the damage outcome may not be entirely sure. Many companies may think it's not really worth the hassle to pursue this. So the idea that resulted in the creation of CDC cartel damage claims was to bundle multiple claims at a material law level in the absence of collective or class action regimes. And the bundling was done by a so-called claims assignment or claims transfer to a specialized claimant entity that is then responsible for bringing the action for compensation. What are the advantages for victims? First of all, it is one single action. So you create synergies and procedural efficiencies because instead of having 10 or 100 or 1,000 individual actions, there's only one action in which the hundreds or tens or thousands of individual claims are bundled. With regard to the damage analysis, you have a broader data and evidence base on which you can prove market-wide effects of competition law infringements. And in the context of settlement negotiations, you have a stronger negotiation position. For the companies itself, it is also an outsourcing of the litigation. The litigation is typically something that companies are not very keen to do. So the affected companies can concentrate on their ongoing business relationships and not on litigation with their suppliers. Our first case involved around 25 assigners. That was the German cement cartel case, i.e. 25 entities that transferred their claims to CDC. It was a purely national cartel and the damage action was filed in Germany. The last case that we pursue, and there you can also see the development of private enforcement in Europe in general, contains claims of more than 1,000 affected companies. It's a pan-European cartel with damage claims from more than 17 member states, and the action is taking place in a bundled manner centrally before the Amsterdam District Court in the Netherlands. So what are the main features of the claims aggregation or the assignment model? You typically are faced with a situation where you have a multitude of persons or companies affected by one and the same infringement. And that is important because this, as you know, competition infringements typically have market-wide effects, i.e., they concern players at the same market level in a multitude of ways. And therefore, the same infringement has very similar effects on multiple customers. The bundling takes place, as I said, at material law level. So we're not talking about a procedural tool contrary to class actions. The transfer is typically done to a specialized service provider or a so-called claims vehicle, i.e. a legal entity, which is then claiming in its own name and at its own risk. It is comparable in a way to an opt-in class action where you have to declare to be part of a action. The specialized entity typically pays for all the costs, including lawyers, economists, court fees, and also provides possibly for the security for costs. That very much depends on each jurisdiction. There is, of course, different procedural rules in the different jurisdictions across the EU. The specialized entity, beside bundling the claims, typically also collects the evidence and the data that is necessary to substantiate the individual claims that are aggregated in the action, i.e., each claim that is transferred is, of course, an individual claim which needs to be substantiated individually. And therefore, the respective evidence, for example, in form of purchase invoices of the cartelized product, are a key element that you need in order to substantiate the damage. Therefore, companies that are active in this field, and we as well, have a need for quite sophisticated IT processes and databases in order to collect the data, but also analyze it and specify the respective individual damage over time. Because of course, sometimes you're talking about cartels which lasted for a long time, where it is difficult to gather the evidence because it's 20 years ago and nobody has kept the invoices. But then it can be quite an advantage to have a broader database from different companies and be able to extrapolate from one company to another in order to substantiate the damage for all companies that form part of the damage action. What are the elements, or how does it take place, the transfer of claim in practice? Typically, it is a so-called claims purchase or claims transfer contract. It's i.e., it's an agreement between the specialized entity that is pursuing the claims on the one hand side and the affected cartel victim on the other hand side. It's a private law contract. The applicable law is typically defined in the contract. And the main element is, of course, the transfer of the damage claims to the specialized entity, to the claimant, which becomes an owner of the claims. The commercial terms typically are a combination of a small upfront purchase price and a variable participation in case of success. Another main element of these contracts is that the affected companies provide all data and evidence required to substantiate the individual damage. The legal base for this model lies in general civil law principles. The assignment or the transfer of claims is recognized in almost all European civil law jurisdictions. It's widely applied in many economic contexts, for example, in insurance contracts, in bank contracts, credits, etc. One exception is the United Kingdom and also in the US, where the transfer of tort law may be critical under the so-called principles of champerty and maintenance. But otherwise, in most civil law jurisdictions across Europe, you find specific provisions in the civil codes on the assignments of claims or rights. Over time, the assignment model in the context of competition damage actions was subject to a number of litigation and to a number of court decisions across Europe. As said, our first case was brought in Germany. Sorry. And there the first judgment concerning the assignment was that the claimant, i.e. the specialized entity, had to provide for security of costs at the time of doing the assignment, i.e. it had to be clear that the specialized entity had the required means in order to pursue the damage action and pay for the adverse costs in case of losing. This is an important element which was not clear from previous case law or legislation, but that has been established by two judgments by the higher regional court of Düsseldorf. Another complex that came up in the context of the German litigation was the so-called German Legal Services Act. Under this act, the assignment is possible, but subject to certain conditions. In the trucks cartel case, the Munich court, first instance court of Munich, held that the assignment is not valid because there's an inherent conflict of interest between the different victims that transferred the damage claims to the claimant. This judgment has not yet been decided in the appeal procedures, but in the meantime, a judgment by the highest German court, the German Supreme Court, provided guidance on the assignment model, not in the context of competition cases, but in other civil law cases regarding flight compensation rights. And there the German Supreme Court very clearly said that the assignment model is possible, and even if there is different assigners with a different background, this should not be a problem. So it contradicted the ruling of the Munich court, and it's very likely that the decision by the Munich court will be overruled in the second instance on the basis of the recent German Supreme Court judgment. In the Netherlands, the model was recognized in a number of judgments, for example, in the paraffin wax cartel, in the cargo cartel, by the Amsterdam Court and by the Amsterdam Court of Appeal. One element that the Amsterdam Court stressed is the need to substantiate the individual claims of the different assigners. So in the trucks cartel case, the Amsterdam Court specified that the claimant needs to specify for each of the assigners each purchase or lease of a truck with underlying documentation and information. So there is a relatively high level of the substantiation of the claim that the claimant has to do for each of the assigners. The assignment model was also recognized in Austria. It was even stated that it's the Austrian type of class action, as well as in Finland by the Helsinki District Court. At a legislative level, it has been recognized in the EU Antitrust Damages Directive, Article 2, Paragraph 4 provides that claimants have an active legitimation in a procedure, including the person that has acquired the claim. And that is a statement that clearly shows that the acquisition or the transfer of claims to a specialized entity is supposed to be valid and provide for the active legitimation in a damage case. Maybe to conclude, the transfer of claims is well suited for antitrust damage claims, not only in case of cartels, but also in cases of abuse of dominant position. As said, it's a bundling at material law level, so it is complementary to procedural law provisions such as class actions or other types of collective mechanisms. It's comparable to an opt-in. I don't think necessarily it is well suited for consumer claims because simply to gather these individual claims is very cumbersome. And you definitely need either IT or tech solutions or another way to manage these cases, because in the end, you're talking about individual claims. What is clear for the damage analysis and for the economic analysis, that the pooling of data from various affected companies is a big advantage and makes it easier to show market-wide effects of antitrust infringements. In the end, it's a commercial agreement between companies and clearly not a procedural mechanism. So it is inherent in the liberty to agree and negotiate contracts. I will leave it at this point for the moment, and I'm looking forward to hear any comments or questions you may have. Thank you very much.
Thank you very much, Dr. Schreiber. And I have few points that I would like to address, but I think it's better to pass the floor to Professor Afferni first, and then perhaps I will give some comments on the both sides of the coin. So thank you very much, and Professor Afferni, the floor is yours.
Thank you, Giacomo. It's also for me a great pleasure to be here with you. and thank you to all the organizer, and thank you to all the public that is attending this conference. As Giacomo said, I'm going to talk very briefly about antitrust class action. Basically, what I'm trying to do is to make a comparison between the American system of antitrust class action and what we may call an emerging European Union system, which, as we will see, is not yet there, because even though, as we will see, there is now a directive on collective redress mechanism, quite surprisingly, this directive does not apply to action for damages for competition law infringement. And this is was quite a surprise to everyone, because as we will see, even though the European Commission started to talk about class action already, I think in the 80s, for consumers, I mean, the first official document, the first official proposal of European Commission dealing with class action, as far as I'm concerned, dealt with the competition law infringement, and this was the white paper in 2008. Okay. Now, I will assume that you are all more or less familiar with the reason why we have a class action, and the reason is, of course, because class action favored deterrence of any kind of infringement, before also infringement of competition law, and by favoring access to justice for victims of this infringement. And on the other side, class actions are also very useful because they allow huge economies of scale. And so class action basically enables the justice system to solve many cases which are all or more or less identical or very similar one to the other with one single trial. Okay. However, class action, I mean, they're very useful, but they're also very problematic because if there are not appropriate safeguards in place, they may lead to abuses, okay? Or at least this is the position which is typically taken in the European Union. As we will see in all these proposals which were set forth by the European Commission, the European Commission always struggled to create a sort of autonomous model of European Union collective redress mechanism, which were different from the American-style class actions. And this is many respects. Okay, before I introduce you with what we may call the emerging EU model of collective redress mechanism, I think it's necessary I briefly explain you what are the main characteristics of the American system at a federal level, even though I assume many of you will be familiar with them. The first characteristic is that in the United States, anyone can bring a class action. So this is not a procedural device which is dedicated only to consumers, but even firms can use it. And I mean, there are no limitation on standing. So consumers, firms, but even public entities, for example. The second major characteristic, and this is perhaps the most important characteristic of a US-style class action, is that American class action are opt-out class action. This means that the decision, the final decision that decides the case is binding not only for the victims of infringement that brought the class action, the so-called lead plaintiffs, but it's binding on all members of the class it's binding on all members of the class, therefore on all victims of the same infringements, with the only exception of those members of the class that specifically opted out of the proceedings. Now, in competition law cases, the individual damage suffered by each individual member of a class is typically quite small, or I mean, it can be high, of course, in some cases, but quite rarely is very, very high. So this, of course, reflects on the probability of victims opting out of the class. So as a matter of fact, in competition law infringement, the number of victims opting out of the class is very low. I think it's the number of 0.5%. So at the end of the day, if and when the case is finally decided, the classes in the United States are very big, are huge in numbers. They're very, very big. A second characteristic of the American system is that this is based on a contingency fees agreement between the lead plaintiff and the law firm that assists the lead plaintiff in court. So as a matter of fact, because of this contingency fee agreement, it's the law firm that finances the class action. I mean, of course, bringing a class action can be expensive, can be complicated. So, I mean, someone must invest money in this venture, which can be successful, but can also be unsuccessful. So, I mean, typically, you would assume that the lead plaintiff will assume the risk of losing the case. Well, thanks to contingency fee agreements, basically, the plaintiff does not need to anticipate nothing because all expenses are anticipated by the law firm. And if the case is won, the law firm keeps for herself a fraction of a slice of the pie, which is paid by the defendant. And this pie, of course, is not made only of a very small pie, which is paid off to the lead plaintiff, but it's the pie of the entire class, which can be very huge. So the amount of money that the law firms specialized in class action in America can do is very high. And this is something I'm sure you're all familiar with. A third characteristic of the American system is the so-called American rule, which is quite exceptional. I mean, in European systems, if you bring an action and you lose the action, you must compensate the defense costs of the defendant. In America, it doesn't work like that. In America, and I think this is quite extraordinary because also in England, you don't have this system. In America, if you lose, you don't pay. You don't need to compensate damages. So for the combined effect of the contingency fee agreement and of the American rule, bringing a class action in the US as a lead plaintiff does not cost you nothing. And even if you lose, you don't risk nothing. You don't need to pay the legal expenses of the counterparty. Now, another very important characteristic of the American style class action is that they are, how can we say, there are two distinct phases of a proceeding. So there is a preliminary, in order for the class action to be admitted to proceed as a class action, it must be certified by the court. Now, basically, the court will need to check that a certain number of requirements are met in order to allow the class action to proceed as a class action. And the most significant, the most important, and perhaps also the most difficult requirements to meet is the requirement of commonality. And so basically, the tribunal must be satisfied to be able to solve all the claims of all the potential member of a class with one single proceedings. I mean, of course, if you allow an action to proceed as a class action and you must make 1,000 or 10,000 or 1,000,000 of mini trial, I mean, you will never, the proceedings will never end. You will have a never-ending proceeding. So it's necessary, of course, and this is a problem that, of course, can be found everywhere in the world where you have collective action proceedings, that the claim that the claims which are bundled together may be trialed together with one trial common to all members of the class. But this is not the requirement I'm interested now, because now I'm focusing, as we will see during my presentation, on those requirements that are that have not been accepted by the EU model. So the requirement I have in mind now is, or the non-requirement, is that in the American system, in order for a class action to be allowed to proceed as a class action, there is no preliminary evaluation of the merits. So the class action cannot be stopped at the very beginning because it's manifestly unfounded. It doesn't matter because it's manifestly without ground. It may be stopped only if some procedural requirements are not met, but there is no preliminary evaluation of the merits of the case. And the final main characteristic of the American class action, as far as competition law infringement are concerned, I want to mention is treble damages. So as most of you probably know, in the United States, if you are a victim of an antitrust infringement, you have, and you suffer damage of $1,000, you have a right to be compensated for $3,000. So your damages are treble. And this, of course, contributes to make American class action so big and so huge, because a lot of victims are involved, because the number of victims opting out are very little. And each one of them has a right to 3 times his individual damages. So the final judgment will have a very high value. And this contributes, together with other factors which are typical of American systems, like the jury trial, etc. This contributes to a very, very early settlement. So very rarely, as most of you certainly know, in America, class action reach the stage of a decision, because typically the defendant, once the class action has been admitted, is not willing to bear the risk of losing, also because the final decision will be taken by a jury, which is highly unpredictable. So typically there is a very strong pressure to settle immediately after the action has been certified as a class action. So this is the American model. The emerging European model is completely different, and we will see how. In Europe, at the outset, we don't use the word class action. The word class action is somehow forbidden because it recalls to your mind the American class action, and this is something that the European legislator, the European Commission, does not like. So in Europe, typically we prefer to talk about group action, group litigation. And within this group action, we distinguish between representative actions and collective actions. Representative actions are actions which are brought not by a member of a class, but by a qualified entity which represents the collective interest of a class. So, for example, a consumer association or a trader association, okay? So in representative action, these qualified entities have standing to sue, to go to court, but they don't ask compensation of damages for themselves. They ask compensation of damages for the member of a class, okay? So it's a different model. It is as if these qualified entities had a monopoly to bring this kind of group action, okay? Collective action, on the other hand, are different. Collective action are group action where standing belongs to each individual member of a group, okay? So they are similar to the class action, but they're called collective action, okay? So when we talk about the European model, we must always distinguish between representative action on the one side and collective action on the other side. So as I said, the first official proposal I'm aware of the European Communion, the first official proposal I'm aware of on competition, on a collective redress mechanism for competition law infringement by the European Commission is this white paper on action for damages for infringement of competition law, which was published in 2008. This white paper foresaw two different kinds of group action: a representative action, which, as a matter of fact, was an opt-out collective redress mechanism, and a collective action, which was an opt-in. So, in the view of the European Commission of the time, American-style opt-out collective action were bad, not a good model. So they admitted an opt-out action, but it should have been a representative action where only certain qualified entities had standing to bring such an action. For collective action, which were also admitted, and actually they complemented the representative action, only the opt-in system was acceptable. Now, the opt-in system is the opposite of the opt-out. In an opt-in collective action proceedings, basically the final decision or the settlement is binding only on the victim that brought the action, and all the other victims that, being part of a class as defined in the summons, opted in the proceedings. So basically, if you are a victim of infringement and you want to benefit of a final decision, you have the burden of opting in, okay? Now, as victims opting out with low individual damages are very few, for the same logic, the other way around, for very low individual damages, victims opted in are very little. And I can give you some examples, if we have time, about the experience of Italian opt-in class actions, which are quite depressing, especially if you compare them with the American-style class action, okay? So, in the white paper in 2008, the European Commission was quite ambitious as far as group action was concerned. She didn't want to introduce the American-style class action because she didn't want to import the culture of litigation, which, according to the European Commission, characterized the United States. But she did want to introduce not one, but two different kinds of group action. So, from the European standards, considered that we were starting from nothing, it was supposed to be quite a big improvement. But as a matter of fact, as I'm sure many of you already know, the final directive, as it was approved in 2014, did not contemplate any group action at all. So the project was completely abandoned. I mean, we do now have a directive on action for damages for competition law infringement, which is very detailed, but in there you don't find nothing about group action or collective action or representative action. The reason was that, at least this was what it was told, that the European Commission abandoned the model of a vertical approach, so a collective redress mechanism introduced only for competition law infringement in favor of a vertical approach because the European Commission started to work on proposals which were common to any kind of infringement of EU law. But there was not the political will at the European level to really introduce such a collective proceedings mechanism. And this is the reason why in 2013, we only had a recommendation on collective redress mechanism, so an instrument of soft law, which was not binding on member state. But this recommendation is very interesting because it gives us the idea of the view of the European Commission on collective redress mechanism. And what were the main features of this recommendation? First of all, only opt-in collective redress mechanism, unless opt-out was absolutely necessary. So there is still a favor for opt-in. Then there must be those are the recommendations made by the European Commission to each member state. Basically, the European Commission was recommending to each member state to introduce a collective redress mechanism with these characteristics. So opt-in, preliminary evaluation of the merits, no contingency fee agreements. So we don't want class action which are financed by law firm as in the United States. The loser pays rule. If you bring a class action and you lose, you must compensate them. And judicial, no punitive damages. We don't want treble damages, and judicial control on third-party founding. So exactly the opposite to the American model. Now, I rush now to the end of my presentation, and I apologize, I lost some time here and there. In 2010, in 2020, I apologize, as a consequence of Volkswagen Dieselgate scandal, finally, in Europe, there was the political input to introduce a directive on collective redress mechanism, which we finally have, and which we will need to be transposed in each individual, in each member state, I think, by 2023, so roughly in 2 years from now. And the characteristic of this future to come collective redress mechanism are very similar to those which was recommended in 2014, because it's a representative action, only in favor of consumers. So this collective action can be brought only in favor of consumers. It's a representative action, so only qualified entities have standing to sue. The decision between, the choice between opt-out or opt-in is left to member states. So what we notice is that there is not anymore this strong disfavor against opt-out. Opt-out is sort of gaining momentum in Europe, which I think is a good thing. But the loser pays rules apply, no contingency fees, preliminary evaluation of the merits, no punitive damages, and judicial control on settlements. So again, it's potentially an opt-out class action, but only qualified entity may bring them. So basically only consumer association, which will have a sort of monopoly for this kind of collective action redress mechanism. And the choice between opt-in and opt-out, as I said, is left to member state. But a lot of protection devices are in places in order to avoid abusive litigation. Now, as I said at the beginning, and then I rush to conclusion, is that this new collective redress mechanism will apply to any infringement of provision of European Union law, which are included in a list, in an annex to the directive. And everyone, me included, when I first read the proposal, gave for granted that this instrument was applicable also for infringement of competition law, because this is where the debate started from, at least in Europe. But if you read the list, Article 101 and 102 of the Treaty on the Functioning of the European Union is not there. This means that this new redress mechanism will not be applicable to our infringement. How is it possible? Now, I ask around. I'm curious, of course, to hear what Till and Giacomo has to say about that. I ask around a little bit what was the reason for that. And I've heard many different stories. And then I finish. Someone talks about lobbies, the lobbies of big industries which are against a class action for competition law infringement. But I don't believe to this story, because if the lobbies were not so strong to stop a class action for others' infringement of EU law, I mean, it's hard to believe that they managed to stop a collective redress mechanism on competition law infringement. But very often, as Till was explaining us later on, has already been established, has already been found by a competition authority. So I mean, I don't believe in lobby. Perhaps the European Commission is working at a vertical instrument. So perhaps in a couple of years, we will have a new collective redress mechanism only for competition law infringement. This is a possibility. Or another possibility is that the European Commission is relying on member states and see what they will be able to do, because as I wanted to tell you, but I don't have sufficient time, we have different collective redress mechanisms in different states, some more successful than others. So there is a sort of competition between member states. Or perhaps, and this is a question I have for Till, the European Commission is relying on assignment of claims. So it's a possibility that the European Commission said, well, we already have a model in Europe which is working very well, which is a bundling of claims through assignment. Why should we introduce a collective action redress mechanism for competition law infringement? But this also does not persuade me completely, because as still already said, I mean, for consumer, class action would be very useful. So I finish here for a moment and I give you back the floor, Giacomo.
Thank you very much. So if I disappear because of poor connection, please go on. Don't stop to wait for me. Thank you, Professor Afferni. Thank you very much. And I think that if we take the full spectrum of collective redress mechanism, the opt-out is surely something very powerful, especially in the American context, with American rule, no contingency fee, and so on and so forth. But if we move to the opt-in, and we think and we compare opt-in and assignment of claim, really we have two models that are quite alike. So I believe that they are overlapping model. Although, however, I have to say that, especially listening to Till's presentation, a thought came to my mind. In the assignment model, you have a very powerful tool, which is the substantive contract that binds the company bringing the claim with every victim. And this perhaps can give flexibility, but also ensures the cooperation of all the potential members that wants to be part of the litigation. So if they want to be part of the litigation, not only they will have to sign the contract and abide by the conditions that the claim vehicle will set, but they will also have to be cooperative, provide evidence, and cooperate to build the claims. Instead, in a purely procedural method, opt-in, let's say, perhaps this obligation is not there. And of course, every member could be responsible for their own failure, but still you lose this valuable information. And this is one remark in favor of assignment. On the other side, the assignment model relies on a substantive contract that can have issues, such as in the German Munich court case, be declared void, or as we know, as we were discussing under Italian law, only specially authorized vehicles can be transferee of claims. And if the assignment contract gets declared void, then you lose everything, and potentially you also suffer from a statute of limitation by then. So really, it's a matter of tailoring the best methods, but I honestly don't think that assignment of claim it's just a step towards EU-wide class action, perhaps opt-in, or maybe even opt-out. It's a powerful model that will stay there for that kind of litigation in which you have a manageable number of claimants with average large claim, let's say. Of course, not €1, but when you get higher, it can be workable. I don't want to steal any more time, until if you have any reaction to Professor Afferni's suggestion at the end or any other comment, please feel free.
Yeah, thank you very much, Giacomo, and also Giorgio, for the very interesting summary. And I'm sorry, but I also cannot shed any further light. For me, the fact that competition law was left out of the directive on representative actions was very surprising as well. And when we looked at the annex, we also couldn't believe that competition law was not in there. My humble opinion is maybe they wanted to leave it to the national legislator, where, of course, in the UK, but also in other jurisdictions, you have collective redress mechanisms which specifically apply to competition law infringements. However, I think as well it's very surprising, given that the aim of the directive is, of course, to protect the rights of the consumers, and it's addressed to consumer relief. And competition law is, of course, a area of law that protects, in particular, consumer interests and the social benefit for consumers. So it is indeed quite surprising, in particular as well, if you look at the enforcement policy of the European Commission, that is more and more focusing on abuse cases where maybe the affected persons are really more the consumers, that there is at least no harmonized framework at EU level for the protection of consumers in the field of competition law.
Thank you, Till. I see that Eduardo Gaban, one of the directors of the Institute, has a question. Eduardo, do you want to?
Can I see online? It's easier. Hello.
Yeah. Hi, Eduardo.
Hi. Good to meet you, professors. Really a real pleasure to me to hear you.
Our pleasure. Thank you, Eduardo.
Congratulations. Hi, Giacomo. Congratulations for the panel. It's easier to ask you directly. How do you see that there are some legislative renovation processes ongoing in Brazil and out of Brazil in some places of the world, to include to enlarge the benefit package for the leniencies beneficiaries, avoiding them to pay damages, or in other terms, including in the scope of the agreement the obligation to recover some money as damages, but ending their liability, civil liability, right? How do you see this in terms of raising the incentives for damage claims after the leniency agreement? Thank you very much.
Who wants to reply to this very interesting and challenging question?
Well, I try to...
Both. First Till, and then Giorgio. I know Giorgio takes...
Giorgio, you want to go ahead? You're already starting.
No. What I could say, but this is probably one of the reasons, or perhaps the real reason, why the European Commission did not at the end introduce a collective redress mechanism for infringement of competition law. Because when the talking about when the green paper and the white paper on action for damages was published in 2008, the private enforcement in the European Union was at a stage of complete underdevelopment, as someone has said. But I think today it's not like this anymore. Now the environment is very crispy, also thanks to what the Cartel damages claims is doing, but there is a lot of litigation going on in Europe. So I would not be surprised, but I'm just guessing, that the European Commission at a certain point was a bit scared of having a very effective collective redress mechanism, such as an opt-out collective redress mechanism for consumers, because since in Europe the leniency beneficiary is not protected from liability for damages, perhaps this could have been how do you say in English, a reason for the leniency applicant not to apply for leniency. So in the long run, this would have made enforcement of competition law less effective. So
Giorgio, sorry to interrupt. I've been told that we have to finish the panel as soon as possible. So just a brief reply from Till, and then we will leave it for a next meeting. Thank you. Sorry, Giorgio.
No, very briefly, I think the point is very important. It's actually reflected in the EU Damages Directive, where the immunity applicant is only liable for its own sales, i.e. there is an exception specifically for the immunity applicant for being joint and several liable for the entire damage. And the discussion for the moment is whether this liability should even be reduced to zero, which I think is not necessarily a good idea, because the leniency applicant, or often it is the larger or the more sophisticated player in a cartel, who can afford good lawyers who then do immunity applications. And then you may end up in a situation where the smaller or the less strong competitors that also participated in the cartel have to pay the entire damage. That's one point. One can maybe think about expanding the benefit to only be liable for your own sales to the second or third even applicant, so that there is more incentive not only for the first one, but also for the second or third one.
So thank you very much to all of you. Thank you for the IBC and whoever listened on YouTube. And I really hope we will have more chance to go deeper into this topic that is very challenging and interesting. Thank you very much.
thank you, Giacomo.
Thank you.
Thank you.
Goodbye. Thank you.
Goodbye. Bye-bye.
Goodbye.